Welcome to Fretton's coffee break briefing of the 7th of April 2025 on the subject of non-provable debts. My name is Malcolm Neekirk. These are the topics I'm going to speak about today. I'm going to be talking about what is a non-provable debt and why it matters when some debts are non-provable. I'm going to be looking at those debts which are clearly non-provable, and then, because I'm afraid this is an area with grey areas in it, I'll be looking at those cases where it is not so clear when a debt is non-provable or provable or indeed something else. And finally, I'll be finishing with some examples of cases where you perhaps quite commonly encounter non-provable debts in your daily work. So let's start with the first of those, and what is a non-provable debt? And in the case of bankruptcies, you have the broad set of all debts and liabilities that the bankrupt owes. And within that, you've got a narrower set of bankruptcy debts. And then within that subset of bankruptcy debts, you've got a subset of provable debts. So in a bankruptcy, a provable debt is one of the bankrupt's debts and liabilities, and it will be a bankruptcy debt, but not all bankruptcy debts are provable, and not all debts and liabilities are bankruptcy debts. And bankruptcy debts are incredibly widely defined. They include all debts that the bankrupt owes on the date of the bankruptcy. They include debts that arise later under an obligation that existed on the date of the bankruptcy, and they include claims in tort for a breach that has already happened, and that's a claim that somebody has got to go to court and seek compensation in damages from the bankrupt. They include other litigation claims that may be made against the bankrupt. They include contingent claims, those that have not yet fallen in, unliquidated debts, those that cannot be valued, and they include debts that are hard to value, and that's a statutory definition in the Insolvency Act itself. And within that statutory definition is an exclusion of child maintenance orders that are made in the family court. Those are not bankruptcy debts. So although they are debts, they're not bankruptcy debts, and because they're not bankruptcy debts, they're not provable debts. The rules for administrations and liquidations are similar, but there is no statutory concept of a liquidation debt or a bankruptcy debt. In that sense, the rules for corporate insolvency procedures and personal insolvency procedures do diverge, and therefore there is no statutory exclusion from liquidation debts because there is no concept of a liquidation debt. In corporate insolvency, you have all debts and liabilities, and some of those debts and liabilities are provable debts. The area where both corporate insolvency law and personal insolvency law converge is when you get to the statutory definition of provable debts. And all debts are provable debts, and those include present and future claims, certain and contingent claims, ascertained claims, and claims that sound only in damages. So it's a very broad definition. And Rule 14.2 then goes on to say that there are various types of claim that are not provable. I won't talk about those in any detail. They'll be on the slides that will be circulated after this. And similarly, if a claim has arisen as a result of out of divorce proceedings or other family court proceedings, it may or may not be provable. It will depend upon whereabouts on this list it falls. And then there are postponed debts, and these are debts which are essentially not provable until you know that you're going to be paying a dividend on them. So postponed debts are paid after all other debts in the bankruptcy or the liquidation. So there's no point in asking the creditor to prove for them. And in fact, you can't ask the creditor to prove for them until you've paid all of the other creditors or know that you're going to be paying all of the other creditors, and there will be money left over for the postponed debts. And then right at the bottom of Rule 14.2, 14.2.5, it opens the door for lots of other non-provable claims that exist under other legislation or under common law. So although it's a fairly long list of non-provable claims in Rule 14.2 anyway, when you get to the end of Rule 14.2 and you see Rule 14.5, you'll see there's a general provision there that says, and any other non-provable claims that might exist under some other rule of law. So there is no single comprehensive list anywhere of all of the non-provable claims. So what are the consequences of the claim not being provable? And in the case of a bankruptcy, if a claim is not a bankruptcy debt, that means it's not going to be a provable claim, and it may be a bankruptcy debt and still also be a non-provable claim. If it's not a provable claim, that means that the creditor cannot deliver a proof of debt for that claim. And if they do, you have to reject it because it's non-provable. Because they can't deliver a proof of debt, they don't get a vote. Because they don't deliver a proof of debt, you don't get to pay them a dividend. As a non-provable claim, they may be able to enforce their claim against the bankrupt by other means outside the bankruptcy. They may be able to bring other types of civil proceedings or criminal proceedings. Depending upon the circumstances, you may or you may not be able to stop that enforcement procedure from going ahead by using the statutory moratorium. And here's a reminder that within bankruptcy, there is this statutory category of bankruptcy debt. There's nothing equivalent to that in corporate insolvency. And in a bankruptcy, if it's a non-provable debt, the bankrupt will still owe the debt to the creditor after they have been discharged from bankruptcy. And that means that the creditor will then be able to enforce that claim through the courts. They may be able to repossess property. In some cases, they may be able to make a claim for contempt of court. They may be able to enforce during the bankruptcy with something like attachment of earnings, in which case there's going to be a conflict if you're making a claim for an income payments order, because you'll both be after the same income from the bankrupt. So there are various ways that the creditor may be able to enforce the non-provable claim against the bankrupt during the bankruptcy, which may be inconvenient for you as trustee in bankruptcy. And if it's a corporate insolvency, like a liquidation or an administration, the company will still owe the non-provable debt. And so it could perhaps be wound up again. The creditor could present a winding up petition. If they present a winding up petition, they still won't be able to prove for their claim in the new liquidation, but they could put the company into liquidation a second time. They might be able to take some sort of enforcement action. And if you get a situation where the creditors are going to be paid in full and there may be a distribution to members, in a case like that, you would then have to treat the non-provable claims as provable, because they would then be payable in priority to any return of money to the company's shareholders. So that's looking at what a non-provable claim is. Let's look at some situations where claims are clearly non-provable. And the examples we've got here are secured liabilities. A creditor who is fully secured, the entirety of their claim is non-provable. If their security is not sufficiently valuable to cover all of the claim that they've got, then the unsecured element will be provable, and they can prove as a creditor for that. In a bankruptcy, statutory student loans are not provable. In all types of procedure, an unenforceable debt is not a provable debt. The most commonly encountered unenforceable debt is going to be one that is time barred. Until 2007, gambling debts were unenforceable at law and were therefore non-provable claims. That law has now changed. And if you're in a situation where you're looking at a debt that a child owes and whether that's an enforceable claim, you're in some very strange territory indeed. And that's actually surprisingly complicated and sophisticated. I'm not going to go any further into that. So that's where it's fairly clear what is a non-provable debt. Let's look at cases where it's less clear. And in particular, I'm going to be looking now at the issue with post-insolvency debts, because they will fall into one of three possible categories. They will be either provable or non-provable or payable as an expense, but they can fall into only one of those three categories. And the rules are not consistent because there are different ways of assessing which of those three categories something falls into. So there is quite an area of overlap, in some cases between two categories, in some cases between all three categories, as to where a potential claim may fall. So broadly speaking, the rule is that if it arises under an obligation that existed at the start of the insolvency, then it should be a provable claim. But if it's on one of the lists of expenses of the administration, the liquidation, the bankruptcy, as the case may be, in the insolvency rules, if it's on that list as an expense, then it will be payable as an expense rather than as a provable claim. And some of those items on that list of expenses are really rather vague, to say the least. For example, what is a necessary disbursement? Or then it may fall into one of the categories of non-provable cases, which may be a statutory definition of a non-provable case, or it may be a situation where the courts have decided that a claim of that sort will be non-provable. And the cases there are not always consistent. So you have to decide if it's a claim that's falling in after the start of the insolvency. You have to decide which of those three categories it falls into, and it may not be easy to choose that. So, for example, we've got the Nortel Lehman Brothers case in 2013, and this dealt with financial support directions and contribution notices levied by the pension regulator on companies in administration. And the decision there is that these claims should be treated as provable debts, which is absolutely fine. But normally adopting or starting something in the administration means that the obligations are a necessary disbursement and therefore an administration expense. So, for example, tax that's incurred as a result of something that happens post-appointment is going to be payable as an expense of the administration. So there's not always a great deal of consistency in the way that those are looked at. There's the Glenister and Rowe case, which is about a costs order made after a bankruptcy order. The litigation was started before the bankruptcy order was made, and it carried on through the bankruptcy. And in fact, this particular costs order was made after the bankruptcy order had been discharged. The bankrupt was now discharged from bankruptcy. And the argument was that this costs order arose as a result of an obligation that had been existing at the time of the bankruptcy order. In this particular case, the court decided that this was actually a non-provable claim. So the discharge of the bankruptcy order did not release the bankrupt from the obligation to pay this costs order, and the creditor could still enforce against the bankrupt for payment of the costs order. This, of course, was the result that the creditor wanted in this particular case, and this seems to be something of a common thread with a number of these difficult cases. Is in a number of them you have the court looking at what it is that the particular creditor wants and is going to be best favoured by achieving in the circumstances. In other cases, the courts are looking at the policy of extending the range of expenses that, for example, an administrator might have to pay, and the effect that would have on the usefulness of the administration procedure. But those policy questions are rarely mentioned in the judgment themselves. And we've got two cases here about rent in administration, which are hard to reconcile. There's the Game case and the London Bridge Entertainment Partners, which was 5 years later. Game case is a very useful one. It says that if the administrator is, as they were in this case, keeping the shops open so that they're trading from the shops, they have to pay the rent of those shops as an expense calculated on a daily basis while they're using the shops. And that's sensible, logical, and fairly easy to understand. In the case of London Bridge Entertainment Partners, the landlord took the rent from the rent deposit that they held. And then they said to the administrators, there's an obligation to make good the money we've taken from the rent deposit. There's a contractual obligation in the lease for you to do that, and another contractual obligation in the rent deposit deed itself. In that case, the court decided that the obligation to top up the money that had been taken from the rent deposit was not payable as an expense of the administration. So that was a different result, which was just a result of the way that the landlord had decided to enforce the remedies that they had. So those are some examples of where it can be really quite difficult to assess what nature of claim the creditor has got, whether it's provable, whether it's non-provable, or whether it's payable as an expense. And that can have quite an important implication on your estimated outcome statement and your final outcome statement. Let's look at some examples now of cases when you're going to come across non-provable claims relatively commonly. And I'm going to be looking at rent, secured creditors, and contracting out of claims being provable. So let's look at rent first. And rent is dealt with in the insolvency rules to say that the landlord's provable claim is essentially for pre-appointment rent up to the date of appointment. That's the basic claim that the landlord has got. And in addition to the basic claim, the landlord also has the right to prove for post-appointment rent, but only as and when it becomes due. So if, say, you've got a lease with 18 years yet to run on it at the start of the liquidation, and let's say that rent is paid quarterly, then every 3 months the landlord can lodge a new proof of debt for the next 3 months of rent that has now become provable as a claim in the liquidation. So you're going to have a claim by the landlord that is going to be increasing every quarter as long as the lease is remaining within the liquidation. And that's where you might decide to disclaim the lease if that's the best way of getting rid of it, which I talked about in March 2025, last month's coffee break briefing. So the basic rule is that post-appointment rent is going to be a provable claim in the insolvency procedure. But in addition to that, if the office holder is actually using those premises to benefit the insolvent estate, then some of that post-appointment rent, while the premises are being used, is going to be payable as an expense rather than as a provable claim. And what it is that triggers that to be paid as an expense is going to depend on the nature of the use, and it may not be the same rule in every procedure. It's too much for me to talk about this morning, I'm afraid. So we have the situation where post-appointment rent is going to be payable either as an expense or as a provable claim. And if it's being claimed as an expense, the obligation to pay it as an expense will end when the premises are no longer being used in the way that triggers payment as an expense. And from that date, the rent falling due will be payable as a provable claim in the insolvency. And that obligation itself will end when the lease is no longer owned by the bankrupt or the tenant, as the case may be, which will be when the lease is assigned to somebody else, or when the landlord forfeits it, or when by agreement it is surrendered, although the surrender deed itself may contain rules about how long the landlord can claim rent as a provable debt for, or if you, as liquidator or trustee in bankruptcy, disclaim the lease, that will bring it to an end. And again, refer back to the coffee break briefing of March 2025, where I talked about the right to claim damages that the landlord will then have once the lease is exclaimed, or if the lease comes to a natural end. So if it's got just 6 months to run at the start of the liquidation, at the end of those 6 months, the lease will come to an end and the landlord will not be able to claim any more rent. That's rent as a post-appointment claim. Let's look at the claims of secured creditors, because essentially if a creditor has got full security for their debt, they don't have an unsecured claim, their secured claim is not a provable claim. In many cases, secured creditors have security that is not valued at high enough to cover all of the debt, so they will have claim that is partly secured and partly unsecured, and they will have a provable claim, of course, for the unsecured part. They will be treated as surrendering their security if they don't disclose it in their proof of debt. So if they make a claim in the proof of debt for the full debt value of their debt without disclosing the fact that they hold security, they will be regarded as surrendering their security. They've got a right to appeal to the court if that was an accident. So there may well be a bit of an argy-bargy about it, but the basic rule is if they don't disclose it, they will surrender it. If they do disclose it and they put a value on it, they've normally got the right to revalue that with your agreement, and it makes sense to be reasonable and helpful about allowing them to revalue. However, if they were involved in the appointment, if, for example, they were the petitioning creditor, or if they have subsequently voted perhaps on your appointment or your remuneration or something like that on the unsecured balance, then it's a bit more formal for them to revalue their security. And if you do agree to let them do it, you have to report that to the creditors. The significance of that, of course, is that from that point onwards, the other creditors then have an interest that would give them the right to challenge your agreement to allow the secured creditor to revalue. So from that point onwards, you're just going to have to be a little bit more formal about allowing a revaluation, and you're going to have to be a bit more careful about ensuring that you're giving your reasons and that you can justify your reasons. Then we've got these two rules, which I like to think of as being your right to play chicken with the secured creditors. If you think that they have put a value on their security which is ridiculously low, you've got a couple of options. One is that you've got the right, assuming you've got the funds to do this, to actually pay them the value that they have put on their security. So they valued their security at, say, £100. You pay them £100 and they then have to release their security and they become a fully unsecured creditor, which could, of course, benefit the unsecured creditors generally, who've now got the benefit of this property that perhaps they weren't previously expecting. Or the second option you've got, if you think that the value of the security is far too low, or perhaps even far too high in some circumstances, you could insist on the property being put on the market, because if the property is sold, then the price for which it was sold will be treated as the value and will replace any estimate that was put on it earlier. So that again is another way of forcing a secured creditor to be sensible and realistic about the value that they place on their security. So that's a bit about secured creditors. Let's look at contracting out, and this is a useful way that you can use non-provable claims. And as office holder, you're going to be making contracts, particularly contracts to sell assets. But if you're involved in a trading administration or other procedure, you may be making contracts for continued trading. And those contracts will normally contain exclusions of personal liability and other types of exclusion of liability to protect you as office holder against claims that other contracting parties might otherwise look to bring against you. And within that list of exclusions of liability, there should be one that says, in effect, even if you, the other contracting party, have got a claim under this contract, then you agree that that claim will rank only as an unsecured, non-provable claim against the company in liquidation. And by doing that, you're giving yourself an extra level of protection against the risk of possible claims being made against you. So that's then covered the four topics I wanted to talk about this morning. We now come to the summary slide. I'll just give a quick recap of the points that I've been covering. So the key things are that some debts are non-provable. Some debts are also defined as not bankruptcy debts in the case of bankruptcy, which effectively is the same as a non-provable debt, but that's tied to a definition in the Insolvency Act rather than a definition in the insolvency rules for historical reasons. They're basically much the same. Provable debts are very, very widely defined, and there are some statutory exclusions to the lists of provable debts, which are the non-provable debts. Creditors may still be able to take action to enforce payment of non-provable debts. They may be able to take that action while you're in office, or they may take action after you've left office. The moratorium that you've got against proceedings being brought by creditors may not be effective to stop a creditor with a non-provable debt from taking enforcement action. Debts that arise post-appointment can be particularly hard to categorise. Now, they will fall into one of three categories. They will be provable, or they will be non-provable, or they will be payable as an expense. And to give one example of one you'll come across quite frequently, post-appointment rent will be either a provable claim or it will be payable as an expense. And which it will depend upon the nature of your appointment and how you have used the leasehold premises post-appointment. You'll also come across secured creditors quite frequently. The secured part of their claim is, of course, non-provable, and if you disagree about the value that they intend to put on their security, there are ways that you can test the value of that and force them to revalue their security if it is at an unrealistic figure. And you can also use the concept of non-provable debts as a useful way of protecting yourself by saying in the contracts that you make that any adverse claims that are made will be treated as non-provable claims, and they'll be treated as claims against the estate, not against you personally. So that's covered the points that I want to cover this morning. I'll now give you the chance to ask any questions if you wish to do so. I don't think I've had any so far, but please do ask or drop me an email, a ring afterwards if there's anything you would like to ask. And I'll give you some dates for your diary. We've got the first of the SESCA insolvency seminars. That's next month now, 22nd of May. We've got the Fratton's 4th annual insolvency conference on Friday the 13th of June. The venue for that is the Bewley Inn in the New Forest. And if you don't know that, it's a lovely spot. It is in the middle of nowhere. There's a railway station, there's a couple of cottages, and there's the Bewley Inn. And over the road from the Bewley Inn, there's a small clump of trees, and there's the permanent site of the pony auction sales in the New Forest. It's open countryside. It's the plains of the New Forest as far as the eye can see in every direction. So, particularly if the weather's like it is at the moment, it'd be a lovely place to be for that conference. So I hope to see you for that. David Kirk ran his insolvency course in the Southwest earlier this year. He's also running it in Cookham near Maidenhead on the 25th of June. There's the SESCA annual insolvency conference at Reading University, 11th and 12th of September. The second SESCA insolvency seminar at Denbigh's on the 2nd of October. And the R3 Smaller Practices Group Forum is in Stratford-upon-Avon on the 19th to the 21st of November. But say the most important of those is, of course, Friday the 30th of June and our annual insolvency conference. And with that, there's my mugshot and my colleague Dom. I will say thank you all very much and see you again in a month's time, if not sooner. So thank you and goodbye.